First, I've heard twice about women don't need 48 hours to make a decision. They already know. The purpose of the Woman's Right to Know Act, when it was passed about 12, 13 years ago, when it went into effect, was to be sure that women get adequate information, because in abortion clinics, they're notorious for not giving information. And we don't have innate medical knowledge, otherwise we wouldn't need doctors. We don't know these things. So after the woman gets information, then she has time to consider that information. Senator Ward asked about the constitutionality of these bills. The only one that has been enjoined would be the heartbeat bill in a couple of jurisdictions. That was in the trial court level. In the House, there was debate, and there was questions asked. Well, this is unconstitutional, isn't it, under Roe? It's never been declared unconstitutional. Roe dealt with one standard, Planned Parenthood v. Casey with another. Every 20 years or so, the Supreme Court re-examines the issue. This may be one of those times when it re-examines. And as Representative McClurkin said about her bill, when you have a beating heart, you normally think that it's a person and it's alive.
And you and I are on the same page. I agree with what you're arguing. The only thing I don't want to do, and again, I apologize for mixing the law with our health care policies. Sometimes it makes a messy scene. The only thing I don't want to do is, I'm pro-life, and I believe to the core, what I don't want to do is I do not want us passing legislation. I think you agree with me on this. I don't want to pass legislation that says we're going to throw it out there to force the Supreme Court to give us a decision. The only reason I say that is because that sounds great in theory, but there's 50 states out there and our limited budgets and what we have to work with. And I think you're saying it's only been enjoined. There's been no ruling by any civil, no circuit yet to say it's unconstitutional,
No,
correct? Thank you, Eric.
Let me see if I can put it this way also. So, if this bill would be enjoined at the trial court level here, would probably go to the 11th Circuit. They're liable to enjoin it there. If no other court anywhere opposes this bill, then that'd be the end of it. The bill's dead. It doesn't go to the Supreme Court. So it's not that much money that's involved. On the other hand, if another circuit rules the bill constitutional, then you have a question that goes to the Supreme Court, and they reasonably look at a new standard maybe for abortion. So, I mean, that's kind of the way I view it. The prenatal hospice bill, that just gives information to people who have a dying child in utero, so that they can treat, have alternative care to help them, just like a person would of old age, where they get hospice. That's all that bill's about, not a burden on abortion. The amendments to the parental consent law, that law's been around since the late 1980s. And unfortunately, it's been abused a great deal. So all this does is it says we want some official information that this is the parent of the girl that's giving permission. And if it's not a parent, it's a judicial bypass, then the judge does not, right now the standard is hearsay. And you know, with the Oy-Tennis rule, we got back to lawyers on the committee. If the judge hears Oy-Tennis and decides here's hearsay, and that's all the evidence he's got from the woman, and he decides in her best interest, and she goes, and someone appeals, the appellate court is bound by what that trial court found because he heard evidence on it. And so they have to basically rubber stamp its decision. This bill would update our law, and it would clarify those things. The same thing with the 48 hour. These bills are updating our laws. They're not unconstitutional. There's no cases that would declare these unconstitutional. So I don't think that there's a burden that would be established that would make them unconstitutional. Thank you.
Thank you, sir.